Andrew, and welcome to the second Bitesize Legal Insights talk. We've designed specifically to be sharp insight into particular topics. We've got some background noise somewhere, I think. So this one today is on how to use terms of business effectively to your professional services firm. Let's start with a bit of housekeeping. If the platform goes down, just go out and come back in. Ideally, please keep your cameras on because it's designed to be a small session and interactive. And at the end, we'd really like to have a chat with you on any issues you've got. If there are any problems with sound quality today, can you put that in the chat box? Andrew's already mentioned that the presentation is being recorded and a copy will be made available to you at the end. So a tiny bit of context for those that have just joined us. What do DGB do? Well, we draft key commercial documents. We provide discrete or ongoing commercial advice, and we advise directors and shareholders on their duties and responsibilities. We also work on resolving disputes. What's our involvement with terms of business? Well, to be frank, we come across them every day. We use them ourselves to regulate the relationship with our clients. We draft them for others, and we advise upon them in disputes. The objectives today, well, by the end of this session, this really quick blast through, you're going to have an understanding of the practical problems of having no terms, the pitfalls of having no terms of business in place. Steve, you're muted. Sorry about that.
Unmute. Can you hear me? Yeah. Thanks, Debbie, and thanks, Andrew, for the very kind introduction. Let's kick off with a whistle-stop tour of some of the practical problems of having no terms of business in place whatsoever. I mean, in short, the most basic issue is that there'll be no contract actually in place whatsoever. That, as you probably appreciate, will have serious consequences, not least that potentially you won't get paid for the work that you've actually done. There's then uncertainty as to what has actually been agreed between the parties and what terms and conditions actually apply. Let's think about this in a practical sense. If we as solicitors agree with a client to do some work, let's say on an urgent or emergency basis, the client might come to us with a request for an urgent injunction, which has to be at court the next day. Well, if we're not putting in place our terms of business, regulating provisions for payment for the work that we do, then of course there is the real risk that we actually do the work, we're not able to rely upon terms of business, and we don't actually get paid. I was a little bit surprised to come across a case as recently as sort of 2019, and that was a financial services case involving fees of around about £1 million, which a claimant wanted to recover, and there were absolutely no terms of business in place whatsoever. The upshot with that case was that the person doing the work, the claimant, actually lost all of his entitlement to the fees, and in actual fact, probably worse, he was branded by the court as something of a risk taker. So that shows you the very practical effect of not having any terms of business in place. I think we could also extend this to having potentially poor terms of business in place. And again, just from experience, I've dealt with a case a number of years ago with a firm of accountants, obviously being nameless, but they were working for a client on a fixed retainer basis. And unfortunately, the terms of business didn't spell out very, very clearly what was included in the retainer and what was excluded. The client thought that the accountants would be doing all manner of work within the retainer. The accountants considered that that work was outside of the retainer and would result in additional fees. therein lay the absolute essence of that dispute. It occupied the court 2 days worth of time to try and resolve it, with plenty of witnesses coming forward to try and explain to the court what actually should have been agreed or what they meant by the retainer. So you'll appreciate, even having terms of business, they need to be very good, they need to be clear, because that lack of clarity will create problems. The other thing to say, just briefly, in terms of business, they're absolutely crucial, not just for new businesses, but also for established businesses. Those businesses need to be keeping an eye on reviewing the terms of business, updating them. I would strongly recommend avoiding templates. They can be used to some extent for generic terms, but not specific to your individual business. So just by way of summary, in terms of having no terms of business in place, then I've identified the risk for your business. Absolutely crucial, the fact that it may well prejudice your entitlement to get paid for the work that you do, causing a loss of income. It throws up risk management issues for your business. It perhaps will almost inevitably lead to disputes, with the consequences for fees and time involved in trying to resolve those disputes. And I suppose finally, at the most basic level, it's going to lead to customer dissatisfaction and possibly complaints again, or damaging potentially the business's reputation. So there's a quick summary of, I suppose, the scurry effects of no terms in place or poor terms of business in place. And I'll hand back to Debbie just to cover what a terms of business might or certainly should include.
You're on mute, Debbie.
Apologies, same mistake as Steve. Sorry about that. So I'm sure everybody here has very wisely got terms of business in place. So let's crash on with what your terms of business should be addressing. Some areas are generic. It doesn't really matter what kind of services you're supplying, you need to address them. So the first thing is identifying what you are agreeing to supply. And that's very basic, but it's actually important. And what I mean by that is, in our terms of business, it makes it clear that it's legal services and the level of competence that you can expect from those legal services. The next point to think about is to make sure that your client knows his or her obligations. We're focusing here on professional services, and we're always going to be pretty dependent upon the information that clients supply to us. So if we're not given the proper picture or key information, it's going to impact materially on the quality of advice or services that we provide. So important to get that into your terms of business. The next one, really obvious one, and probably at the foremost of everybody's mind, is payment terms. Cash flow is key. Why on earth would we do any work for anybody that we weren't going to get paid for? And actually, if you want to know a bit more about that, our next Bitesize event is totally focused around cash flow, process and payment. But really important to cover that off in your terms of business. Termination is a generic one. You need the right to terminate. What happens if you've got a client who instructs you and then just doesn't give you any instructions or timely instructions or proper instructions? You need to be able to bring that contract to an end. You might want to, your payment terms might include provision for payments on account or interim billing. And if you don't get paid, if you don't receive the money, that's an alarm bell, and you need to have the right to terminate on that basis. Insolvency on the part of your client is also a big issue. I'm not going to go into that today because you'll probably know about SIGA in 2020 and the impact on insolvency. So it's an area in itself. But in ordinary times, insolvency is something that you want to think about. Liability, depending upon the type of work you're carrying out, the type of clients that you are dealing with, you might want to include limits, geographical, financial. You need to look at, you will want to look at your professional indemnity terms and make sure that you're not exposed to more than you've got indemnity for. Serving notice. If you don't specify how either party can terminate the contractual arrangements, what amounts to termination? Is it a casual chat on the telephone? A meeting in passing? How do you prove that you've terminated your arrangements? So you always need to consider including specific provisions for termination. And think about the method as well. Email, formal letter, how is notice to be delivered? Confidentiality and data protection. Confidentiality might be very important to your client. In fact, you might already have signed an NDA. And data protection is key to every business. This is a statutory obligation. I think with terms of business and statutory obligations, it's an opportunity to demonstrate that you've got an awareness of the obligations and can actually be a strong point when you're sending your terms of business over to a client, can be reassuring. Money laundering, another statutory obligation. You'll want to impose the right to see relevant documents and carry out ID checks. The right to carry out ID checks is pretty important now because post-COVID, we're doing everything electronically. Dispute resolution, agreeing to perhaps arbitration or the appointment of a third party to provide a view on the dispute. That can be very useful. And again, depends a lot on the kind of services you're supplying. Governing law could be very important if you're working with international clients. And bear in mind, even if you're working with clients in Scotland or Northern Ireland, those are different jurisdictions. So if you're based in England and Wales, you want the law of England and Wales to apply. Because the moment you move into Scottish law or the law that's applied in Northern Ireland, there are differences. There's differences in the law itself and in the process. All generic things that I've talked about, but depending upon the services that you're supplying, there also might be specific things you want to consider. And intellectual property rights can be very important. If you're providing anything creative, so with architects, we could be talking about drawings, a branding company, it might be designs. If you're doing marketing, it could be digital content. You need to think about ownership of what you're supplying when it passes. I certainly think it would be pretty heartbreaking if you'd produced a fantastic campaign, the client was using it and they hadn't even paid for it. So you need to think about those kind of things. I'll finish up on this section with where to start with preparation. So I'd look at the generic heads that I've outlined, the services you supply, think about the implications of those services and do a list of any past problems you've had. Because if you're going to have a bash at doing terms of business yourself, or you want to instruct a third party like ourselves to prepare those are the questions that need addressing. Whoever's preparing them, they need to understand the problems and challenges you've had before. So I'll pass back to Steve now for incorporation. And Steve, you're not on mute, so third time won't be unlucky.
Thanks very much. I'm good to go. Okay, dealing with incorporation. Let's use an easier, simpler word. And I think probably that would be the word apply. So it's asking what terms of business actually apply to a contract. Let's think about it practically. I'm pretty sure over the last 12 months or so, we have all applied or incorporated terms of business. Let's think about our Amazon orders where we've ticked the box, we've accepted the terms of business. Insurance contracts, For our home insurance, car insurance, we've probably ticked a box confirming, yes, we accept the terms of business. Holiday bookings, perhaps not so much in the last 12 months. Phone contracts. So we've dealt with all of these things and they have incorporated, have been subject to the provider's terms of business. In terms of problems with incorporation, one example I can give, a building dispute where an order is placed with a supplier subject to your terms of business. However, on delivery of that supply and on the invoice for the supply of the materials, there are an additional second set of terms of business on the reverse of the document. The question then potentially will be, which terms of business apply? The first set, the second set. What the courts have told us over the time is that the absolutely key principle is that all of the terms and conditions in a document must be provided to the other party prior to or at the time of the contract. That's the incorporation element. You might have heard the expression a battle of the forms, and that's exactly the scenario that I've mentioned with the building invoice, where you've got a series of sets of terms of business, and it will be for the court to determine which actually applied to that particular contract. The other expression you might have come across is what's known as a last shot, which pretty much means that if there were 2, 3, 4, 5 terms of business, the last one upon which the contract was based will be the ones that actually apply. I think the watchword really for me will be to be absolutely clear that when you are contracting, that you are certain on what terms the contract is formed. That has to be at the centre of your attention. So in terms of a couple of practical points, best practice points, in terms of your professional services terms of business, keep them updated, review them, ensure that, for example, increases in hourly rates or changes in insurance are dealt with and the terms of business updated. Crucially, send them out. It's only then that you can be absolutely sure that your potential client is clear as to the terms upon which you're going to provide your service. Not only send them out, but get them back. Have a system whereby there's a signed receipt or an acknowledgement, basically an acceptance of your terms of business. Absolutely crucial. That will then ensure that your terms of business apply to that particular service that you're providing. The final point, I suppose, is retain the documents. Unfortunately, as we know, disputes do arise, and have systems in place to record the contract, to be able to retrieve the relevant documents and keep those for, I would suggest, a minimum of 6 years. 6-year period being the limitation period, the amount of time that has to expire to enable disputes to be resolved. So what I would say is, if there's any concerns about either perhaps the basis of a contract, variations to a contract, the incorporation of terms, possible disputes, then get some legal advice as soon as possible, because those matters can be addressed and potentially resolved without them escalating any further. So on that point, I'll hand back to Debbie just for some summary points.
Yeah, thanks for that, Steve. I think that point, I would say it because I'm a lawyer, but I am just going to emphasise about when things go wrong, about getting the correct legal advice, because if things go wrong and you continue to trade you might lose your rights. So I won't be any more technical than that, but I'll just mention it. So in summary, hopefully we've demonstrated today the value that well-drafted terms of business can provide for you, and the importance of incorporating them. I know the incorporation point might seem such an obvious one, but you'd be amazed at what we've come across over the years, where people, the classic all the time we get is, yes, I did that, yes, I did that. Can you show me? Can you show me the letter or the email where you sent them out? Oh, well, we didn't keep it, or oh dear, we didn't send it. So systems with your clients are really important. And if you follow these tips today, then you'll have clarity in your contractual arrangements. It'll help you with your cash flow. It'll protect your business. And actually, it's important for customer satisfaction as well. Expectations are clear from the outset.